All legal cases are different, and you should seek the advice of your own attorney before acting or making decisions. No attorney-client privilege applies to communications on this show, and no attorney-client relationship is created by calling or writing in. Attorney Rominger practices only in Pennsylvania and maintains his primary office in Carlisle, Pennsylvania.
Hey! Welcome back, 540-0580. All right. Don.
Yes.
What's going on?
Oh, I'll tell you. I've been playing horses at different tracks in various states for 30 years. And last week I was at our local track, and I grew up and bet in a voucher machine, telebet. And it's the first time in my life I got the shock of my life. If you make a mistake on a voucher, it comes out, you put it back in, and it says, yes, I want to cancel it, or no, I don't. And this particular case, this voucher, I made a mistake, and it went over $100. And it come up. I put it back in. I tried to cancel it. It said, no, over limit. I put it in again. I got frantic. I tried to get my voucher money back. It refused, and then the race went off, and I got stuck with the ticket. I talked to what I thought was the head teller, and he said, they don't at over 100 limit. And he said, what if I'd have made a $10,000 bet and so on? It would have messed up the track odds and doing it at the last minute and so forth. It was my mistake. So I was out over $100.
Right.
And previously I canceled tickets under $100.
Right. So I'm not sure I understand, but I think basically use those machines at your own risk under Pennsylvania law, if I had to guess.
Well, I didn't know that there was a particular rule that if you made a mistake in a voucher over $100 that they refused to give you your money back or cancel the ticket.
Wouldn't everybody who changed their mind claim a mistake too? Isn't that part of the problem?
I don't know. My mistake was that I punched the numbers in incorrectly, and I was in a hurry because I was running out of time for the race. And
right.
So you don't think I got a case, maybe?
I don't think so.
Oh, wow.
All right, bro. Especially because it's only $100, and for what you have to pay a lawyer, $500, you might as well just bet that too.
Well, if I could beat them, because it really injured my ability to want to play after that, because it really shakes you up psychologically. Losing ain't one of the names of the game, Okay, well, I have one other question.
Yeah.
Own a half of a double house.
Okay.
And I abandoned the chimney. There was a chimney that was put through the center of the house. It supplied both units. 30 years ago, I switched to electric heat because of the basement being frequently flooded. And the neighbor didn't, but the neighbor continued to use the chimney. I closed my side off. Now the chimney needs repaired. It's a possibility it could fall down on the neighbor's side, or it could fall on my side and do my property damage. Am I obligated to continue repairing that thing, or is it my neighbor since I no longer use it in over 30 years?
Oh boy, it's part of a duplex.
Yeah.
It's a shared chimney.
Well, it was at the time.
Right.
30 years ago, the original owner, I changed to electric and closed it off, and they were aware of it, and then it was sold twice since then.
I don't know the answer to that one. It seems like it's a shared chimney. It's just part of the shared portion of the structure. So I don't know. We'd have to look at the deed, and we'd have to look at how everything was done. But I couldn't give you an answer off the top of my head. But it sure seems like you probably might have an obligation to it, even though because you voluntarily stopped using it, doesn't mean it stops being a part of your house.
Yeah. Well, like I say, I cemented my side shut in the basement, and when you go to electric heat, you don't need a chimney anymore.
No, I understand that, but I'm thinking about it from the standpoint of the portion that belongs. So just thinking out loud like a condominium, there's portions of a condominium that belong to the inside of the house belongs to you, and the outside belongs to both. And a duplex like that, I'm not clear. Does it literally run up the middle of the property?
Yeah.
Yeah, so the portions on your half is probably your half, and the portions on his half is probably his half.
Well, it looks like about 3 or 4 inches, like a 12-inch chimney, and it's an 8-inch block wall that separates the two buildings, and it's like 4 inches out in each side of that wall.
Yeah, interesting.
Yeah, right. Okay, well...
conundrum, my friend, conundrum.
Learn something every day, I guess.
Yeah.
Okay, Carl.
All right.
Thank you very
Good
much.
luck.
Yep, good.
540-0580. Michelle, you want to get in on the horse topic?
I do. Our granddaughter, somebody purchased a horse for her last Christmas, told her that it was a Christmas present, and they're not inside our family, they're an outside source. And with that, she went over and stayed and helped take care of their house and their daughter. That was the agreement. So anyway, she went off to college. Mm-hmm. Well, she had this horse up at a ranch near her up at her college. That's where she had it because she was going for equestrian medicine. And the horse, she had to pay board for this horse. Well, this person said they would pay the board. Okay. She never paid the board. Now the board is $1,800, and she cannot go back to her next semester if it's not paid, and she's in her second year. And what I wanted to know was, he went in, she had taken care of the horse in the morning, went to classes, went back out to the barn at 7 o'clock, went in, her horse was gone. Everything was thrown all around, and the horse was gone. And she had that horse in shows and all kind of stuff, and she paid that for herself. Mm-hmm. But what I wanted to know was, I don't understand, can he just take that horse, or can she go to court and prove that it was a gift?
Well, I mean, she could prove it's a gift. I mean, delivery was made, right?
Right.
So
they delivered it up there for her.
That's what I mean. Delivery was made, so that's one of the issues. So there's yeah. I mean, she could possibly prove that was a gift.
Okay. Because she did the upkeep for it. She would go out and groom it and do everything she needed to do. And
it's a fact-specific question. I mean, if they intended it as a gift, then it's a gift. If they intended it as payment for something, then it's hers. If she was supposed to do something but didn't, then maybe, then they can claim breach of contract as well. But they're certainly worth sorting out the rights. What's the horse worth?
She was going to $5,000, $3,000 to $5,000. She told me that the reason she was over at their home was because they had a daughter her age, and they belonged to this church. I think it's like a cult thing, but anyway, they wanted her to show their daughter and keep an eye on their daughter when they would go away, because their daughter was into drinking and things like that, and she never did that. Mm-hmm. And I think that's why they chose her to come there. And their daughter rode a horse also. But now this is one of the main problems, though. She came to us, and she called us this morning. We used to put like $20 in her account so she could have gas, because she's like 90 minutes from our home. And when she needed things out at the college. So what I want to ask you, she owes, they're saying she has to pay this $1,800 before she can go back to her next semester. And I know that man's not going to give it to her. Right. So what we want to know is if we as grandparents, because all we would be able to do is use a charge card to pay the bill, because we don't have that kind of money. Mm-hmm. And we both work, but, we raised her, and we just don't have that kind of money to do those things. So what I wanted to know was, if we pay that $1,800, is there any way, because she has like 6 to 8 more years to go to college, is there any way we could get that back on our taxes or something? Does that make sense, or doesn't it? I don't know what to do.
No, I don't know why you would get it back there. The only way you're going to get it back is if somebody sues and successfully collects the money. And when did she find out they weren't paying this?
2 weeks ago, they took the horse. They took the horse 2 days before Thanksgiving. That's when they took it.
Right.
And that's when she found out. She went to the school to fill out her papers again for the next semester for her grants, because she carries a 4.9 average. And when she went up there, that's what she was told.
Yeah, I don't know what the answer is. I really don't.
I mean, because that's part of our retirement money, and we don't have like $50,000 to retire on. This is money that will need. And what I wanted to know was, if we pay that, can we get it back like as a gift from somehow, or I don't know.
Well, I'm not sure what I understand. What I'm understanding, if you pay that, that's just money you paid. If she's owed that, or somebody owes it, she needs to pay you back, or somebody who is supposed to have paid it's got to win a lawsuit against them if they won't pay it voluntarily.
Would she be the one that would have to file the suit?
It would seem to, although she could assign her breach of contract to you, and then you could bring the lawsuit.
Okay.
But it doesn't sound like a straightforward case, so it wouldn't be one that it sounds like a slam dunk.
Okay.
So you might end up spending $1,000 in attorney's fees and not collect anything. Then you're going to be out, what, $2,800?
Oh, okay. I understand now.
All right.
Okay. I guess that's how we're going to have to do it.
All right. Sorry about that.
Thank you very much
All right.
for your information.
All
Bye.
right. Good luck. 540-0580. See you after the break. I just had to kick Bob Durgan out of the studio to come back on the air here. Feel bad. I hope you people are happy. 540-0580 is the talk line number. Chris, you're on the air.
Hi, Carl. How you doing?
Good.
Quick question. It's kind of stupid, but I have a concealed weapons permit to carry, carry my gun, and the reason says for hunting. Now, if I carry it on a regular basis for protection, could that ever get me in trouble that I don't have that for the reason?
No. The reason, you're supposed to give a reason why you want one.
Yeah.
But once you
issued
one, you have all the things appertinent there too.
Okay. All right. I just want to make sure that all the people call in and hear stuff about that. I'm like, oh, crap. So.
Right.
All right. Well, that's it. Well, thank you, Carl.
All right, my friend.
Bye.
They always tell you put target shooting down, right? Don't put self-defense because that supposedly raises a flag. Or, put to kill people on the application. And then later when they deny, you can say, I meant as lawfully entitled under the law, right? Because you are lawfully entitled to kill people under certain circumstances. Doug, you're on the air.
Good afternoon. The subject is liability waivers. For years I've been signing these things for Y camps and basketball and all this kind of stuff with kids. And I thought, because I practice a little judo at home with some friends, do they mean anything? Should I have one? Is it nonsense?
They do help because they create a clear disclaimer and assumption of the risk style defense, okay?
Mm-hmm.
But, they're not absolute bars to lawsuits. And there's already an assumption of the risk doctrine involved in sports as it is.
Yeah.
So, for instance, when you go to the golf course, you assume the risk of getting hit by another golfer's ball, even if he negligently hits it into you.
Right.
Of course, there's a case out of Cumberland County a few years back where the court found that one does not assume the risk of an unannounced second tee shot because that's not integral to the game.
Yeah.
And then there's one against the Carlisle Country Club where a guy got hit by a ball from the driving range, and you don't assume the risk of getting hit by a driving range ball when you go onto a golf course. Well, you might if you're on the driving range.
So what's the additional protection? You have to buy insurance or?
Yeah, the additional protection of the waiver is just to add basically in there a clear statement that you're waiving things that are other acts of negligence that might not fall squarely within the assumption of the risk.
Yeah.
And so, do you absolutely have to have the waiver signed? No, it's not going to provide a bulletproof defense, and a lot of times the person's still not going to have a claim, but it's to help patch up those areas where it gets a little unclear or a little fuzzy.
Yeah.
So the unannounced second tee shot, if your buddy had signed a waiver, he would have waived ordinary acts of negligence, and then you could do an unannounced second tee shot and hit him in the head.
Yeah, sure. So I guess if you're doing some of these things for any period of time, you should find another coverage, right?
If you're saying what, people just coming over and hanging out, social guests, your homeowner's policy will cover just casual issues.
Casual athletics, that sort of thing?
Yeah.
Homeowners?
Yep.
Oh, Willis? Oh, okay.
You're playing a little flag football in the backyard. Now, remember, there's supposed to be negligence for somebody to collect.
Sure.
There's supposed to be negligence. So, what is the negligence when you're playing flag football and you leave an iron stake in the ground and somebody falls on it?
Yeah, right,
Ouch.
Exactly. Yeah, exactly. Well, I always like hearing your opinions. Thanks very much.
Yeah, let me leave you one thought. You ever go over and play volleyball at anybody's house where they stake out the volleyball net?
Yeah, sure.
And they got it staked out with those big iron pins and everybody's lunging around in the grass. I always get a kick out of that, but I'm always like, someday, somewhere, this is going to be really bad.
Oh, yeah.
And then, of course, you can get the jarts out, too.
Yeah, well, it should have been a rubber stake or something. Yeah.
I knew some people, by the way, who used to go around to yard sales and buy up the old jarts because, you can't buy them anymore. And they like to play it so much.
Yeah.
And I'm like, there's a reason why you can't buy those anymore.
Yeah, of course. Listen, have a good weekend.
All right, take care, my friend.
Okay.
540-0580. Helen, you're on the air.
Hi, Carl. I was calling in to give you a heads up on this new child abuse laws that may come up with that committee that was set up after the Sandusky thing. The head of it was this judge, David Heckler. And he was the senator back in 1995 that tried to push through gun control laws and attach them to a child abuse bill that was being voted on in the lame duck session at the end of when Governor Casey was leaving. And I'm just afraid, I know we need new laws to take care of institutions and who all should be reporting, but when I finally remembered why this man was, tugging at my memory cells, I really want gun owners to be watching these child abuse laws so that he doesn't sneak something in there, because I'm sure that 18 years later he is still virulently anti-gun. And it really amazed me that he was a Republican. And I was at the hearings and overheard him talking with that NRA guy, Ho Hen Warder. Mm-hmm. So I mean, I heard what they were talking about, said something to him, but, I was, a person there in my biker jacket and boots and didn't look like I was anybody worth listening to. But, I've already called some other gun owners that I know, and I'm calling you to tell you, please watch it for us.
Understand. And I don't know what else to tell you. He's no longer in the Senate, right?
No, he's no longer. He's a judge in Montgomery County. He was a senator from Montgomery County back in 95. And, I went to the hearings because I was, a member of Victims of Child Abuse Laws and also worked for the Welfare Department and was interested in them. So I took time off on my own to go and listen to these hearings, and that's why I was there and overheard him, and I was just astounded because I am a gun owner. And I just, my mouth fell to the floor. I couldn't understand why the NRA guy was conniving with him, but of course, Governor Casey, he refused to attach it to that bill back then because he wanted a clean bill, and also because he remembered that the gun owners were the people that had gotten him in office.
Right. Looks like he's from Bucks County.
I thought they said Montgomery. I'm not sure. It might be Bucks.
It looks like Bucks County.
Okay.
So you're saying he's an anti-gun guy?
Yeah, and he was in charge of that committee that was looking into writing new laws.
The Task Force on Child Protection.
Yeah.
Interesting.
But you all are busy. I'm not. I'm sitting here at home, retired, and.
Well, that's good. Then you're doing your civic duty. You're out there figuring out what's really going on.
So, all right. Take care.
All right. Take care. Bye-bye.
Bye.
540-0580. David.
Yes, Carl.
Yep.
I have a question about when somebody dies without a will. First, is my understanding correct that if there's a property involved and the property is jointly owned, with rights of survivorship, that property is not part of the estate?
Correct. Correct.
Does the surviving person though have to pay, or
potentially
the estate,
there will be tax? Yes.
They taxed on the for the estate tax.
Yes, potentially there will be tax.
That would just be on half the value of whatever.
Correct. I mean, that's the general rule. Now, if if it was created within 1 year of death, then it's possible it could be the entire amount.
Okay. Now this is like 5 years ago. Does an estate have to be opened at all just to dispose of an old car?
That's the answer I like to give, which is no, because if there's an estate and it's insolvent and everything else is taken care of, why bother? Now, what do you do with cars and things like that? That can be a problem, but they can ultimately end up at the scrapyard. I've seen people drive them until they fall apart. I'm not sure that's great legal advice.
Well, this car's already 20 years old. So.
Yeah. So a lot of times what ends up happening is you can, I had a guy, he had I think it was his father's car on his property. His father had died. It was worth maybe $500. We didn't want to open an estate. So he called the police and says basically, hey, somebody parked their car on my property and I want it tagged as a car that shouldn't be here.
Right.
And then the salvage guy comes in and takes it once it's appropriately tagged by the police. He does his job that PennDOT requires him to do, and when nobody responds, i.e. because there's nobody alive to respond, he gets a salvage title and scraps it. So, lots of different ways to work around it.
Okay, well, appreciate it and appreciate your service to the community.
Thank you very much.
You're welcome.
540-0580. I want to remind you guys, because I did this at the top of the hour, December 11th at 7 p.m., I'll be speaking on gun laws at the Northern York Fish and Game at 40 Bremer Road, New York. It's free and open to the public. December 15th, we're going to have the gun trust lawyer on here, David Goldman. He's going to be joining me to talk about gun trust and what you can do to get a gun trust. He pitches gun trust both for people who want to just put their guns in a trust to keep control of them outside of test state or outside of the estate planning issues, but also so that you can own potentially without certain requirements of federal law, automatic and other types of firearms. Very interesting stuff. January 19th, David Goss from North American Forensic Accounting will be here on February 2nd. Glenn Yoder from Caldwell Banker. And we'll be back with you after the break. Hey, welcome back. Carl Rominger here. By the way, we're going to announce, after the next break, we'll announce the winners of the Facebook competitions for the Rillo's gift certificate. So we'll take care of that. Mike's up next. Mike, how are you?
I'm doing fine. How are you?
Good.
Good. Just wanted your perspective. A friend of mine has recently come across some hard times, and it's not going to be able to afford to be in his apartment anymore. And to be the good human being that I am to help him out, I wanted to let him stay at my place until he can kind of get back on his feet. But being a good human being sometimes can come with some consequences, and I'm thinking, all right, if I'm being a good human being, letting him stay at my place for 6 months or more, is there anything I should think about? I mean, I'm not a landlord, but, is there anything I should think about, Carl?
So he's going to be moving into where exactly?
My residence, so owner-occupied.
So he's going to be in there with you?
Yep. Mm-hmm.
You could sign a short lease with him with an agreement, as to what your expectations are.
Okay.
And you'll have to evict him like anybody else once you let him in. So you should just treat it like you would any other tenant.
Got it.
So have a clear understanding of what's to be paid. You hate to run any situations, a clear understanding of how long they're allowed to stay. Are you looking for a roommate for life, or is this just to get him back on his feet for 6 months?
Yeah, we just want to help him get on his feet.
Well,
but
and the reason I say this, I mean, I've heard the story is, kid breaks his leg in the 8th grade, right? Mm-hmm. And then he's on crutches, and then somebody else has to carry his books for him. Mm-hmm. But magically, he never gets off the crutches because he discovers that now everybody will do all his work for him. And that's the point. The point is you got to make it clear what I'll carry your books for you for a few weeks, but then you better start working it out. Get down to one crutch, and then down to none. All right?
Yep, that makes a lot of sense. I appreciate the perspective, Carl.
No problem. Take care.
You too.
540-0580. Howard, you're on the air. Hey, Howard.
Hi, Carl. I was calling because recently I got a ticket for speeding, and I was really disappointed in myself because I'm not a speeder. I haven't gotten a ticket for speeding in over 30 years. But I got it on one of those things where the police had the white lines out there, and the guy timed me. And my question is, I want to make a good affirmative defense for what happened, and I wondered if I could, what sort of things I might be able to do. One of the things I thought about was if the guy has a dash cam, would that be something I could bring up and say, I want to see this as evidence?
Well, yeah, kind of. If the police officer has a dash cam and they've saved the tape, certainly can use it. My experience is they don't pull them for speeding events or other minor things. Sometimes they do.
And
go ahead.
So if he didn't have the dash cam and showed up at trial at the hearing, is that something where I could say they destroyed potentially exculpatory evidence?
You could, and the court's way of saying it is well, you may be right, and we can take an adverse inference from that. But the officer's testimony still controls, and if we find him credible, it doesn't matter if there was a video or not.
Okay.
Yeah.
So there's really not much you can get in the way of advice as to try and handle that and maybe get away with
If you have a really bad stop, okay? Let's assume you have a really bad stop and things go really awry and you're upset and you really think you need this tape. What I do is I immediately send a letter to the police department, the district attorney's office, and the person who would have been in the car, and basically say, hey, you have a tape. I want the tape. If you're going to prosecute me, preserve the tape. That way, at least later on when you get to court, it's much harder for them to say they never pulled it or didn't realize it would be evidentiary or inadvertent. You know what I mean?
Yes.
And
so I don't need to try and subpoena it. I just need to send a letter.
Well, you can try to subpoena it, but I'm talking about by the time you have a hearing, their 30-day retention period, for instance, will probably be up, right? Or whatever their internal thing is. That's why I'm saying I whiff those letters off. Like, so if I get pulled over on a Tuesday or a client gets pulled over on a Tuesday and they come in on Wednesday or call me up and I think there's a real issue, we whiff those letters off immediately.
Okay.
See what I mean? That way later they can't go, well, we never knew this tape was going to become an issue. That's why we never pulled it.
Gotcha.
So when the judge is trying to figure out whether to take an adverse inference, and hey, one time I had a case, right? There's a drug stop, and they claim that my guy consented to the search of his car. My guy claims he did consent to the search of the car, but not after 40 minutes of being berated and a whole bunch of other crazy things happening. The police agree there's a tape of it. By the time we get to trial, they say, well, we tried to copy the tape, but in copying the tape, we accidentally erased the tape. But we were able to salvage from the hard drive a little bit of information, and it's only an audio file. Somehow the video disappeared, but the portion of the audio we could surface, we could salvage, includes your guy consenting in the 2 minutes of audio that survived.
How could you keep a straight face?
Yeah, the judge ultimately threw that one out, but didn't use that basis, but just found the stop was an improper stop and that they detained him too long, etc. But I think that didn't hurt my position, right?
Right. So I guess what you're telling me is I may be stuck with this ticket.
It might be. You have other defenses too, though.
What might that be?
Haha. Well,
long story.
Why don't I send you my cake recipe too?
Okay. Thank you, Carl.
All right, my friend.
All right.
540-058. David, you're on the air.
Yes. How are you doing there, Carl?
Good.
I don't want a cake recipe, but I did want to answer. I was involved with a business. The business went belly up. There's a debt of about $10,000. Someone filed a complaint on. I was involved in real estate, so they're not going to get anything out of me. I don't have anything. I got washed out pretty much. So I ignored it, and then I get this amended complaint that I guess they're resending it for some reason. Then I ignored that. Then I get the letter. The letter they send you saying you have 10 days to respond, or you're going to be in default.
Right.
But I'm 2 whiskers away from bankruptcy, and I'm spending most of my energy on that because that's where I'm going to have to go, unfortunately. And I'm not complaining. I've had a good life, and I did very well for a long time, but it's just the way it rolls sometimes when you get out there and all that debt. I don't plan to respond to this, so I know there could be some consequences, but like I said, I don't have much that they can go after. But if I decide I want to go to a lawyer and respond to this within that 10 days, will that put me back in the ball game, or have I already, by missing the complaint when it was first sent out 20 days ago?
No, when you get a 10-day default notice, you got 10 days to respond, and if you don't respond within 10 days, then it's a race to the courthouse, whoever goes first. But if they default you, then if you try to open the default with a meritorious defense within 10 days, you'll be okay.
Okay.
So you need to move fast.
Okay, so I could still, if I woke up tomorrow, got a lawyer,
yep.
And I'm on the 3rd day here. If I go past that 10 days, they get there first with the answer.
Then you get behind the 8 ball a little bit more than you already are, but you still have hope. But you can easily get with a lawyer. Make sure any lawyer you contact knows about these deadlines, though.
Yeah.
If you call my office and ask for an appointment, my crazy secretary will schedule you 3 weeks out. If you tell her, hey, I got a deadline, here's the deadline, and I need to see a lawyer before the deadline, then they'll work at getting you in.
Okay, now one other thing. Let's say I call there, and they're going to tell me, of course, you want to bring everything with you and so forth. Okay, I need to bring everything when I come to that first appointment.
Right.
So that everybody knows. Now, what about things that are filed down at the courthouse? Could there be things, that they didn't send me that are filed down there?
There could be. There could be.
Okay. Do I go down there and ask for them, or do I just come to you with what I have?
I just get to the lawyer with what you got, and they'll let you know if they need anything else.
Okay. Now, I have one other question on things called preliminary objections. Do I waive my right to preliminary objections once that letter comes?
No. You can still do preliminary objections at that point.
Okay. And so you can use all those tools. If I decide I want to come to you, you can use all those tools then. All right. Well, thank you very much. Who do I ask for? I just call over and just give them the information?
Yep. And we'll get with one of the lawyers. The office number is 241-6070. That's 717-241-6070.
Oh, I have that right in front of me. And I just tell them, look, I've got 5 days on this.
Yep. And say, I talked to Carl on the radio, and he said to get me in here.
Now, what if they say they get back to me and 2 days go by? Should I just keep calling?
Yeah, I'd call the heck out of them.
All right. Thank you.
All right, my friend.
Bye-bye.
Bye. 540-0580. Let's take one more before the break. Mark, you're on the air.
Hey, Carl. Hey, great discussion you're having with Bob there yesterday. I wanted to follow up on something on divorce versus ground divorce, no fault versus ground divorce. I wonder, I'm thinking that the state really should look more at no fault / grounds for divorce. Because with no fault, you're basically giving a guy or a girl the right to go out and cheat, and the worst that's going to happen is they lose half their possessions, which, means they got a prenup. Right. I'm going to get 50%. Versus they should put some fault back into it. If I cheat on my wife, well, the judge can say, okay, she gets 75% of the assets because you're the one who cheated.
Right.
Or if you both decide, okay, you both want a divorce, fine, no problem, no fault, here's your paper, sign. What do you think about that versus what we do nowadays? Because I just think you're giving some people a license to misbehave, and there's no consequence other than the fact that they're going to end up with half the marital assets.
Well, that is a consequence, though.
What?
That's a pretty big consequence to lose half the marital assets, right?
Right, but if you come in as pretty much, unless you like if somebody has a business or something like that, and then guys like that will get a prenup anyway. Me and my wife, basically, we got married. We were pretty much equal coming into the marriage. Yes, over the years, I've earned more money than her, but we've always worked together. So if I decide, okay, I want to go out and fool around now, and she catches me, what's the worst that's going to happen? I'm going to have half my marital assets. I'm in good financial shape. It's not like I'm not going to be starting from scratch.
Right.
Versus if she decides, well, tell the judge, hey, he cheated on me. I want 75% of the assets. Give the judge a right to say, hey, yeah. You're the one who broke the marriage vow,
Yeah, and okay, I'm thinking this through. You can already do that because if you do a fault divorce in front of the master can use the fault as a basis for shifting distribution to different than a 50-50 scheme as one of the many factors they can consider. Same with alimony awards as well.
Oh, so that is already in the law.
There is the ability to do it, although because fidelity is just one of many, many issues, it doesn't become controlling.
Oh, okay.
All right.
Well, like I said, I would just like to see them tweak it that way. Give the court a little more authority to say, hey, you do something wrong in the marriage, you're going to pay for it. Maybe that would maybe give guys or girls a little more thought for care before they start wandering around or something like that. Because right now it just seems like
I got to go to break, brother. Got to go to break, but I got it. All right.
All right. Bye-bye.
All right, I'm going to announce the winners here. You're going to have to go to the Rominger and Associates page and or my page on Facebook to find the exact things they wrote. But number one, funniest thing at a polling place, I'm going to give that to Cindy Pennington because when she moved to Adams County, she had to go to I think it was a janitor's office and vote on paper ballots, or at least on paper ballots anyhow, and was like, what? Imagine that going back in time. Of course, here in Pennsylvania, they love that stuff. Number 3, what was number 3? That was just anybody who wants to win and why. It went to Jim Scarborough because he seemed very whiny, like he should win, so we gave it to him. And the number 2 best traffic stop goes to Christy Rao, and there's a reason for that. And I can't really even tell you her story on the air except to say that she said something completely outrageous to a police officer at the traffic stop, which was completely untrue, but was just mad because they kept pulling her over every night when she was driving a certain route. And but when the police officer got the punchline, he got the joke and thought it was very funny as well and waved her on her way. So that story is beautiful, but I can't give you all the details. So you're just going to have to go to Rominger and Associates and pick through those best stories and see it. And I'll put a link up, of course, on the Carl Rominger page as well. 540-0580. Dan, you're on the air.
Yeah, Carl?
Yep.
Hey, I got one for you. It'll take a minute. I'll give you the base of it, and then there's the special parts to it. But basically, my family member, elderly gentleman, was in a car accident. He lost consciousness due to health problems, and he head on with another car. But his airbag didn't go off. The passenger side airbag went off, but his didn't. And he sustained injuries, hitting the steering wheel and all. So we were told by several people we should, take up counsel because, that was a defect that should have not have happened. So we did. I won't say the car company, but after about 2.5 years, they settled. And it turns out what it basically comes down to is the lawyers are getting 40% plus their fees out of $250,000. So it comes to about $120,000, leaves $130,000 that Medicare is taking because of all the medical needs he had because of the accident. They want all of it. So basically, he sued for a lawyer and for Medicare to make money. He's getting nothing for pain and suffering or anything.
Well,
the reason why it was such a high amount was after the accident, he got ill when he was in a nursing home during rehab, and they discovered he had a lot of medical problems that were unconnected to the accident.
Right.
They found all kinds of problems that they didn't know about, but they would have found eventually, or he would have died eventually. But they had nothing to do with the accident, and the lawyers can't seem to convince Medicare of that. They want every dime they can get from it. So the last we heard from his lawyer was they're going to try to split his fee, meaning that if we did not sue this car manufacturer, Medicare would be getting nothing. So at least you can pay half the fee.
Right.
I was thinking of calling some kind of congressman or somebody to contact Medicare because it just seems so unfair that, he was better off if he just didn't do anything. Let's put it that way. He's just making money for, to pay back something that would have been paid for anyway, even if he didn't have the accident, because he would have had to have treatment. It just seems so unfair, the way it's turning. I just didn't know if you had any suggestions.
I mean, I'd have to look at everything and understand what's going on, but it's not unusual where the liens can exceed the award. Would they run out of insurance?
Yeah, the insurance paid for a lot of different things. He was pretty critical. And then when that ran out, I guess Medicare took over as far as the nursing home part of it and rehab. And that ran up a pretty good bill. But when they discovered his gallbladder was dead inside him, they had to remove that. He needed a quad bypass. He needed a carotid artery fixed. And all that really added up, and that's where Medicare wants their money. And that had nothing to do with the car accident. So I didn't know if I was be able to go after maybe the surgeon and have him write a letter explaining that these were, unrelated items.
And your lawyer's not doing this?
I haven't talked to him. It's really none of my business as far as that they're dealing. I just feel bad that it's happening this way. And he's older, so his attitude is pretty much that's just the way life is, And I'm like, it just seems so unfair.
Right.
He's the one who had the accident. He's walking away with nothing.
Right. Yeah. No. I understand that. So, I mean, I'm thinking out loud, but it doesn't seem like an injustice if everything falls in that way because it has to. But maybe you don't settle. Sometimes we go to the other side and we say we're not taking a settlement because client's not getting any money.
Yeah.
So we get everybody to break ahead of time so that we know that we can settle it. I don't call it an amateur mistake, but I've seen cases where somebody agrees to a settlement, say for $100,000, not really knowing that the lien, for instance, is in excess of $100,000 for some reason, and then the lien holder says, "Give us all the money."
Yeah, doesn't matter. Doesn't matter who the lien holder is. Could be the government or it could be healthcare in general.
It depends on the type of liens, because some liens can be brought down by different reasons. For instance, some liens are subject to an attorney's fee portion. Some ERISA liens, for instance, are not. So there's a lot of homework that has to be done. You know, when I'm training a young lawyer on these things, I'm quite often saying, you got to get these policy manuals, you got to look at these subrogation rights, you got to get all this stuff together ahead of time, and then don't enter into a settlement until there's money for the client. I don't like what you're talking about, only because it seems like the lawyer made money, but there's no money for the client. Now, if it got to a position where only the lawyer could make money and on paper there's nothing better that can be done, I would hope that the client would go, okay, well, I guess if there's no way anybody's going to get any more recovery for me, I'm not going to actually net anything, but you did look into it and do all this work and try, okay, I'll agree to it, right? But other than that, I would want to be 100% certain.
Yeah, so I guess that'll be my suggestion to him, that they, make sure they did everything they could, and I'll see if they contacted the surgeon or anybody to show proof that way that all that medical treatment had nothing to do with the accident.
And it could be it could require a declaratory judgment action or some other court action to get a court determination as to what actually was caused by the injury or accident or not.
Oh, okay. All right.
Okay.
All right. Well, thanks for the info. I appreciate it.
Right. Good luck, my friend. 540-0580. Andrew, you want to smoke some weed?
Yes, I have a neighbor that has a noxious weed issue, and we have a farm. We run cattle, and it's Jimson weed, which are poisonous. The seeds are poisonous to cattle. I'm concerned about them spreading over onto our land, and I'm kind of wondering what I can do about it. The kicker is it's a PennDOT road project, and I've talked to them and begged them, and even though it's the law, and I told them so, they pretty much just said, well, tough luck. And it seems like they're above the law.
I don't know. So they're planting it. They're planting this noxious weed where you run the cattle.
Well, it's right next door. I mean, it's right on the border. They didn't plant it, but they allowed it to grow.
Huh. Well, let me know, and I'd be interested in talking to you about it.
Okay.
All right, my friend, I got to go.
Thank you.
All right, guys, sorry who's still holding. We ran out of time, but we'll be back next week. Or in the meantime, law office number is 241-6070, 717-241-6070, 717-241-6070. See you next week.